Right, well, the first thing to ask you, first of all, to say thank you very much for joining me this evening. And the next thing is to ask, were you all able to attempt the home tasks which I sent to you? Yes, I need you to, good. Did anybody have any particular problems with the home tasks, or were they all fairly, they should have been fairly simple? Did you find them fairly easy?
I did find them fairly easy, but there were a few here and there cases that I would, it would be nice to check against the answers.
Okay. Now, I sent you the list of answers in a separate sheet. Did you get that separate sheet? Or with the answers on them?
I didn't, but I don't, maybe other people.
In that case, I will send it to you this evening or later or tomorrow morning. I'll send you the answers. Let me just let somebody else is just joining us. Okay. Okay. Well, let's let Sergey in as well. Excuse me. I'll give the others. I'll give them one more minute just to let other people join, and then we'll start. Okay. Good. Right. Well, I'll send you all the answers. I'll make sure I send you the answers this evening, if I haven't already sent them. Okay. Well, now, what I want to look at this evening is vocabulary. We're going to continue with writing, but I want to deal with some vocabulary this evening. Now, most of you are in the UK. I know that you're interested in working in legal firms and in the law in the UK. So I want to deal with the vocabulary of the legal profession in the UK. You need to know what you're talking about with regard to paralegal, solicitor, barrister, judge, article clerk, associate, etc. So we're going to turn to a book which I showed you at the end of the last lesson, which is the, let me get the name of the title of the book right, which is the, from the, where are we? Oh, it's gone. Oh, there we are. The Lawyer's English Language Coursebook. Right, Lawyer's English Language Coursebook. So what I'm going to do, we're going to have some exercises looking at vocabulary, and we're going to have some exercises dealing with listening for detail. First, I'm going to show you the vocabulary. I'll let us let Mark in as well. First, I'll show you the vocabulary, and then I'm going to read something to you and ask you to listen for detail. Listen to each word I say. And then we're going to have some exercises to answer questions on the text, which I'm going to read to you. If we have time, we'll go to a second text, and I will invite some of you to volunteer to read, and then we'll have more questions on the content of the text. Right, so let's share my screen, first of all. I'm going to invite all of you now to switch off your cameras because it will divert power away from the audio. If you switch your cameras off, all the power will be diverted to the audio. So if I can invite you to do that. I'll share my screen now. Okay. And Sergey, I'm going to invite you to switch your camera off, and Joan, I'm going to invite you, if you can, to switch the video off on your iPhone, but if you don't, that's okay as well. And now let's go to the Lawyer's Legal English Coursebook. Let's increase the size of this. Let's move that out of the way. Right. Well, hello. You know, of course, many of you are at the Law Society event, so you know they're all solicitors. They're basically office-based lawyers, but they have rights to appear in the lower level courts. They can apply to have that extended to be granted advocacy rights in the more senior courts. In America, there's just one legal profession, and I believe the same in Ukraine and in many countries around the world. We just call them attorneys. But in the UK, they're split into two parts. The office-based lawyers, there's about 90,000 of them, and the specialist courtroom lawyers. Here's a picture of one, a barrister with this wig and this special gown that they wear and this special collar. These are specialists in appearing in court. They are basically specialists in advocacy, and they have specialist knowledge of the rules and laws of evidence. And all of them, solicitors, attorneys, barristers, they're all lawyers. Right, that's just the generic name. Now, what's a bit more useful is this vocabulary. We know what a lawyer is. Okay, you know what an attorney is, just a lawyer. They are all qualified as lawyers. Those who deal with court disputes and arbitration disputes, we call these disputes, when they go to court and they start court cases, we call this litigation. The barristers have authority to speak in any level of court, the Supreme Court, the most junior courts, and all the courts in between. We call this ability, this authorization to speak in court, the right of audience. All of these lawyers are authorized to work in the law, that is, to practice law. The most senior lawyers are appointed as judges. In the common law courts, to be appointed as a judge is a mark of considerable distinction. I know that in Ukraine, sometimes it's not regarded as a particular mark of distinction, but in the common law countries, only lawyers who can prove themselves as highly competent lawyers are allowed to be appointed as judges. Now, all our work is called legal practice. We practice law. We don't work as lawyers, we practice law. So your business is called your legal practice. Those of you who are applying for jobs with law companies may ask the law company, what area of legal practice does the company work in? Now, advocacy is the work of speaking in court. The people who do this are lawyers, and what they're doing is they are being advocates. They are advocating on behalf of their clients. And this right of audience means the right to appear in court. Defendants appear in court. Complainants appear in court. People who are summoned or who have legal proceedings appear in court alongside their advocates, whether the advocates are solicitors or barristers or just qualified attorneys. Now, the bar, which is the regulatory body for barristers, deals with these specialist advocates. All of these forms of lawyers are only allowed to qualify after they've received their law degrees, and then after they've received a further period of training within a law company or a barrister's office, known as a barrister's chambers. And to take this training period, you need a training contract. Lawyers, in general, solicitors, work with other solicitors in a law office in a partnership. It's not a limited company. There's a huge difference in that a partnership is an association of people working together with a common objective, with a view to making a profit, but they are each responsible for the debts of the business. This is not a limited company where they can escape from the debts, and they're each responsible for the debts of their partners. Now, solicitors can enter into a partnership, and indeed there are global partnerships. Slaughter and May, Simmons and Simmons, DLA Piper. Barristers, however, are not allowed to enter into partnerships. They work with other barristers from communal offices known as chambers. They each pay a monthly amount to pay for the rent of the premises and to pay the court, pay to their clerks and secretarial staff. These are their fees that they pay to running a barrister's chambers. Right. Now, when we go to court, we act as advocates, then we plead a case. This is the language of the priests from 1500 years ago, when the priests were the only lawyers left in Britain. So we plead a case. That is, we speak on behalf of our clients. Solicitors do this in the magistrates' courts, the junior criminal courts, and in the county courts, the junior civil courts. But when you get to the High Court, the Crown Court, which is the higher level criminal court, only barristers have rights of audience to appear and act as advocates. When we appear on behalf of our clients, then we say we are acting for our clients. People may come to see you in the office and ask you to take on a matter for them, maybe help them buy a house, or sue somebody, or send a letter demanding somebody pay a debt. When we take on these people, then they become our clients, and we act for our clients. When we write to whoever we're writing to, we say we are acting for Mr. Jones, our client. We go to court and we represent clients. Sometimes lawyers work in niche areas of law. Of course, they do the same in Ukraine. Shipping law, insurance law, banking law, in which case we specialize in these areas of law. Yeah, very easy, right? Very easy. No complex words here. It's just becoming familiar with the way in which we use the words and the small differences that appear between, say, rights of audience and advocates and pleading a case and representing a client in court. So I'm going to read a text to you. We're going to use all these words in the text, and then you're going to help me answer all these questions. Right. So I want you to listen for detail, for exactly what I'm saying. Okay. I'll read this out loud now. There are two types of lawyer or lawyers who practice in England. They are called barristers and solicitors. In the USA and most other countries, lawyers don't make this distinction. A lawyer is simply known as an attorney at law or an attorney. In both England and the USA, it is not, I'll just let Deanna in, excuse me. In both England and the USA, it is not possible to take a special exam to be a judge. If you decide that you want to be a judge, then you must get a lot of experience as a lawyer first, then apply to be a judge and wait to see if you are chosen. Most law students in England become solicitors. When they finish their university studies, they do a 1-year legal practice course and then a 2-year training contract with a law firm. After that, they are qualified solicitors. Many solicitors work for a legal practice, which is usually a partnership of solicitors who work together. Solicitors practice in many areas of law, although each solicitor usually chooses to specialize in one particular area. They represent their clients both in and out of court. We often describe this as acting for a client. The process of making a claim in the civil court or civil courts is called litigation. Now, barristers. Barristers are self-employed lawyers and don't work in partnerships. in the way that solicitors do. They're specialists in advocacy, which is the skill of speaking for someone in court. We call this pleading a case. They also give opinions on areas of law to solicitors and the solicitors' clients. It is not just barristers who have the right of audience in court. Solicitors are also allowed to represent their clients in court, and many solicitors appear in court every day. It is not true to say that a client always needs a barrister in court. The distinction is this: the bar themselves have said that if the case is particularly simple, no complex matters or issues, then clients can go direct to the barristers who can be instructed by the client direct to appear on the client's behalf in court. If, however, the case is complex or large amounts of evidence needs to be gathered, then it is preferable that the barrister instructs the client or tells the client they should instruct a solicitor, and that the solicitor will then instruct the client. And the solicitor will do all the work of gathering the evidence after dealing with difficult technical issues involving evidence for the client before instructing the barrister. Right, now, I've read all that to you. So you've got to tell me whether these statements are true or false. What I want you to do is to write true or false in the chat box. And chat box will appear at the bottom of your screen if you use your cursor or mouse. So is it true or false that there are two types of lawyers practicing in England? Is that true or false?
True.
Okay,
True.
I want you to write the answers in the chat box for me though, rather than speaking, okay? Good. Let's see what the chat box says. True, correct, very easy, right? Next. Here's a statement by somebody. Last year, I finished my training contract and I started working for a large international law firm. I'm now a qualified lawyer. Is that true or false?
True.
Well, let's see what you've got in the chat box, okay? False. Now, Anna, correct. Why is it false? Well, let's see what they say. They do a 1-year legal practice course and then a 2-year training contract. So he said, last year I finished my training contract and I started working. Well, that's...
But it was for a lawyer, not for solicitors. Maybe I don't understand
Okay.
correct answer, because it was qualified
well, you
lawyer.
see, that's right. You see, to become a solicitor, it's a large international law firm. So it's a firm. That means it's solicitors. So to become a solicitor, you got to have a 2-year training contract.
Okay.
Okay. Well, actually, that's quite possible, quite right. Possibly that is true, in fact. Let's have a look at this. Everybody says it's false, but...
No, because it says last year
I finished my training contract.
He could have had it for 2 years, but just last year he finished it.
So in fact, it's true. So in fact, that's true. Yeah. Okay.
True.
Yeah. Okay. Right. Can I ask you to all mute your microphones, just so we don't hear the background noise? Okay. Good. Right. Let's go back to this. Now, is it true or false that only barristers can speak on behalf of clients in court? Don't speak, just write true or false in the chat box.
False.
Okay. But I don't want you to speak. I want you to write in the chat box so the others aren't guided by your answer. Correct. It is false. All right. Good. So don't speak. All right. Now, is it true or false that many solicitors work together in partnerships, but barristers do not? Don't speak, just write in the chat box for me. Okay. Yes, it's true. And is it, again, don't speak, but just tell me true or false. Is it true or false that in the USA and England, lawyers can take a special exam to be a judge? Just write the answer into the chat box for me.
Oh. I'm sorry.
True.
No, false.
Okay, I'm laughing because, oh, there we are. Okay, correct, it's false. It's false. You don't take any exam. You can't study to be a judge in the common law courts. You've got to prove your ability as a lawyer first, and then you're invited by the judicial body of your country to become a judge. You can apply for a job, but you've got to prove your ability as a lawyer first. Okay, now then. Okay. We're talking about barristers. Barristers are, of course, involved in litigation, that is, suing people and being sued and appearing and representing people in court. Now, in general, there are two different types of law in the common law countries. There's the law relating to criminal matters, crime, punishment, prisons, and there's everything else. All civil law, family law, banking law, land law, commercial law, every other type of law other than things that relate to criminal law. So lawyers, there are a lot of lawyers working criminal law. Lawyers in the UK and in most common law countries refer to themselves either as criminal lawyers or civil lawyers. Civil lawyers can be anything: corporate counsel, working in company law, banking matters, insurance matters, shipping matters, family law matters. And then they're the civil lawyers, and they work in any field of law that is not a criminal law matter. Right? Easy as that. So you tell me now which type of lawyer is needed for these type of situations. Mr. Bellaby is opening a new factory. He needs to visit a lawyer to get a contract for all of his employees to sign. Is that a criminal matter or a civil matter?
Civil matter.
Speak that.
Civil.
Don't. Don't speak, okay? I'll tell you when I want you to have a conversation. Just write civil or criminal in the chat box. Civil. Everybody's right, it's civil matter. Okay. Now again, don't speak, just write in the chat box. This is what the situation is. Mrs. Robinson, is thinking about what she wants to happen to her house and possessions after her death. She needs to visit a lawyer to get the correct document, which is called a will. This is also called a will and testament. It's an written instruction, or an instruction in a permanent form, could be a video, about what is to happen to her property after she dies. So is that a criminal matter or a civil matter? We've got 10 answers. Let's see what we got. Yes, it's civil matter. Now, let's see. The police are talking to Mr. Dean, or the police are taking Mr. Dean to the police station because they say he stole the car. He needs a lawyer to come and visit him there to tell him what to do. Is that a criminal matter or a civil matter? Good. That's a criminal matter. Good. Let's jump ahead to E, the last one I'm going to ask you. Mr. Allen is a bank manager. The bank is saying that some money is missing. Mr. Allen has a new car and expensive clothes. The police are coming to ask Mr. Allen some questions. He needs a lawyer immediately. But does he need a criminal lawyer or a civil lawyer? Does he need a lawyer who knows about banking matters or a lawyer who knows about criminal matters? Is it criminal or civil? That's 9 of you. Anybody else going to give me an answer? Let's see what you've said. Yes, it's a criminal matter because he may become what is called a suspect. The police are suspicious about the new clothes and the car because where has the money come from? So he may be a suspect. If the police think they have sufficient evidence to prove that he took the money, that would be, well, it's not corruption, Natasha, okay? if they think he took the money, then they may think he's stolen the money, which is theft. Corruption is a criminal matter, but it's not theft. Theft has a specific definition under the Theft Act 1969 in the UK. Section 5 of the Theft Act, and this is the typical sort of thing a solicitor would tell you. Section 5 of the Theft Act defines theft as the dishonest appropriation of property belonging to another with the intention of permanently depriving the other of it thereby. That is theft. Corruption, well, corruption is taking money or bribe. That's dealt with by the Anti-Corruption Act, which is something from about the year 2000, the Corrupt Practices Act 2008, which is a different matter. Right. Now, let's jump ahead. We talk about legal topics, a case. We don't call it a case. I've got a court case. What we say is I've got a matter, a criminal matter, a civil matter involving a will, the legal document, or the permanent legal record, usually a document, but it could be a video, it could be something else, in which a person gives details of what they want to happen to their property after they die. It's a civil matter. We say it's a shipping matter, a banking matter, a family law matter. We give more details, it's a matter. And to steal, to take something that belongs to someone else with the intention of keeping it. That's a rather feeble definition. To dishonestly take something. The dishonest part is what we call the mental aspect. In Latin, we'd call it the mens rea. I'll write that down for you, because those of you who may get involved with law companies may well be asked to help out by going to the police station to deal with people. So each law, each crime usually has two sides. First of all, there is the mens rea. This means the guilty mind part, the intention to do something dishonest, the mens rea. And then we have the physical act, the act to actually taking the money, taking somebody's wallet, driving the car away. This is the physical action of the crime. We call this, again, it's more Latin, I'm afraid, but you're going to have to get used to this. We call this the guilty act, known as the actus reus. So each crime has two aspects: intending to be dishonest, and then actually physically doing something dishonest. Taking the clothes from the store, that's the actus reus. Knowing that you haven't paid for them, intending to steal them, that's the mens rea. All right, let's move on from that. Now, what we've got again now is another text, right? This is all about starting a claim in the civil courts. Lower level courts in the UK are known as the county courts. There are county courts in every major city and some minor ones as well. There is a maximum limit of amount of money that you can claim in the civil court, in the county court. If you want to claim £50,000, then you wouldn't start in the county court. You'd go straight to the high court, the higher level court. But to begin with, you'll start off in the civil courts. Now, what I'm going to do this time is I want some volunteers. We've got some reading. It's boring to listen to my voice, and I want you to practice your English and your pronunciation. So what I'm going to get some of you to do is to volunteer to read these paragraphs to me, one paragraph each, and then you're going to answer these questions on it, okay? So again, listening for detail, but this time listening to each other, right? So who would like to volunteer to read the first paragraph?
I can.
Thank you, Jan. Right. And Mark, you're going to read the second paragraph. That's great. Thank you, Mark. Right, Jan, you read about this paragraph headed starting a claim in the civil court. Don't go too quick. Just read it out loud for us, okay?
Okay. Starting a claim in the civil court. When you are in dispute with another person, sometimes it is necessary to start a claim in the civil court. We sometimes call this process filing a claim or
Good.
issuing a claim. Lawyers also say starting proceedings. We do not use the verb to prosecute in civil law because that verb is only used in criminal law. In England, most civil claims are filed in the county court. There are over 200 county courts in England and Wales. Most cities are large towns have a county court.
Right, stop there. That's great. Good pronunciation. And notice we said filing a claim, not filling a claim. Filing means to put papers in the correct place, in the file, or perhaps filing papers in court, in the correct office in the court. To file something means to put the papers in the correct place. Good. Now, Vitali, you put your hand up as well. Vitali, read the next paragraph for us, please.
Do you hear me?
Yeah, we hear you. It's good. You go ahead.
The person who started the claim is called the claimant in the UK. This person was called the plaintiff until 1999, when there were new court rules in England to make everything easier for people to understand. However, in the USA, the claimant is still called plaintiff. In both England and the USA, the other party is called the defendant.
Good. Now, in family matters, and for example, divorces, issues over paternity or access to children, in these family cases, we don't start cases called a claimant or a defendant. We start a claimant with very, very old English. We issue a petition to the court, a petition, meaning a request to the court. And the person making the petition is called the petitioner. Obviously, there's somebody who's going to answer to this. So the person on the other side is not called the defendant, but the respondent. Now, these family law matters are also dealt with in the county courts. Okay, so petitioner and respondent. This is the language of the priests from 1500 years ago. All right. Now then, who else raised a hand? Vika, you put your hand up as well. Vika, would you like to read for us the next part about a claim form? Yeah.
Form is the document that a claimant uses to start legal action against the defendant.
Good.
Why might a claimant start a claim? There are a lot of reasons. Oh, for example, should I continue?
Yeah, please continue. Yeah, please continue. Yeah.
Someone refuses to pay you money that they owe you. Someone does a job for you, but they do it badly. We call this bad workmanship. Something that you paid for is not supplied to you. Something that you bought is not working properly.
Good. Okay, very good. You step there for. And Katerina, would you take over and read the next paragraph, please?
Yes. The claimant has to pay a sum of money called a court fee for the court to issue proceedings. In the claim form, the claimant must state the amount of his or her claim and request the defendant to pay all of the legal costs of the case. Okay,
so now stop there for a while. That's fine. And now we're going to hear about a very small court called the Small Claims Court. Let me see, Natalia, can you read this for us, please?
Yes, of course. Sometimes people talk about the small claims court. They really mean the special procedure that exists at the county court for small claims. A small claim is a claim for a maximum amount of £5,000. This amount will probably increase in the future.
All right. So those are the sort of junior courts of the civil law, okay? The county court and the small claims court. And the small claims court is part of the county court. In particular, in the small claims court, you don't need lawyers, although you can take one with you if you want to. But basically they're for, as I say, small claims, £200 or £300, arguments between neighbours over damage to a fence, things like that. And it's very informal. It's run as a court, but the judge try and make it as easy as possible for people to go there without lawyers. Let's have a look at these questions and answers, okay? And again, I want now now I want you to stop speaking, okay? I want you to write true or false in the chat box to these questions. Now, is it true or false that starting a claim means the same as starting proceedings? True or false? Starting a claim means the same as starting proceedings. True or false? Let's see how we do. True, correct, very good, everybody. You can prosecute someone in the civil court. True or false? False. Very good, everybody. Very good. Well, this is very easy for you. This is good. Is it true or false that there are more than 200 county courts in England and Wales? True. In fact, there are about 47 counties, I think, in England and Wales, where we've got 200 county courts. Every big city has one. Right. Now, is it true or false that the word plaintiff is not used in England anymore, but it is used in the USA? True. Now, for an extra bonus point, so to speak, what word do we use for the person who brings a claim in the civil courts in the UK? We call them the what? Write that word in the chat box for me. Claimant, very good. Now, number D, letter D. Letter E, I beg your pardon. True or false, it is free to start a claim in the county court? False. Quite right. You must pay court fees. It is called, even though we didn't call them plaintiffs, we call them the plaint fee. The amount of money that must be paid to start the case. It's based on a sliding scale, depending upon how much money you're claiming from the other party. Right. And is it true or false that there is a special court in a special building for making small claims? Now think very carefully about what you're being asked here. Think as lawyers. Is it true or false that there is a special court in a separate building for making small claims? True or false? Okay, 9 of you. Let's see what you say. False. Absolutely. Everybody's got it right. Very good, everyone. False, because although there's a separate court, special court, it's not in a separate building. It's within the county court building itself. Very good. Right, now we're going to have some more vocabulary. These are phrases or words that we use with regard to cases where people are suing each other, which we call litigation. Litigation, to litigate, to bring a court case against somebody. First of all, you wouldn't bring a court case. Quite right. You wouldn't bring a court case against somebody unless you were in dispute with them. To dispute, to argue. So to be in dispute means to have a serious agreement with another person. Yeah? a word which would describe an argument in the law, a formal word to describe an argument in the law is a contention. Let me just write that, okay? You are in you're in contention with somebody. Contention means argument. So in court, you would say we would contend that. That's what we would argue. Right, a party to a court case is, of course, the claimant or the defendant is one of the two sides. They're a party to the court case. So you say, well, I'm a party to a court case. People say, well, which? Are you the claimant or the defendant? Yeah. Now, to owe money to someone, well, that's a debt. To owe money to someone. This is usually what most county court claims are brought over, unpaid debts. To have to pay for someone for something that they've done for you or given to you. Legal costs. Well, these are the legal expenses of bringing a claim. The court fees, the money you pay to start the case, and payment for the lawyers or acting for the parties, these are legal costs. And usually in the civil courts, it's part of the judgment. Not only will you have to pay for what the money that you owe, but you'll also have to pay the legal costs on the other side if you lose the case. The fees they paid and the money they paid to their lawyers. Now, a procedure. It's a formal word meaning a decided way of doing something. There's a set procedure to starting a court case. The summons must be issued, it must be paid for, it must be stamped, and then it must be served on the other side, who will have a certain number of days in which to respond to it. That is the procedure. And to prosecute, well, to prosecute, this is a criminal word. It's to take legal action against somebody in the criminal court. I'm going to prosecute you for assault. I will prosecute you for stealing my car. The police will prosecute you for assault. Right. Now then, what we got here? Here are some phrases, and here are the mixed up definitions. Number one has been issued for us, deleted for us. To issue a claim means to start a claim in the civil court, right? Right. Well, here's the next, number one on the right-hand side. This means to confirm you've received the claim and to say what you will do next. Which of these words, A, B, C, D, E, F, G, or H, means this? To confirm you've received the claim and to say what you're going to do next. Again, don't speak, just write the letter A, B, C, D, E, F, G, or H in the chat box for me. Or now, next thing is this. It's boring if you don't have a try. Now, if you could do all this without my help, I wouldn't have any purpose. So don't be afraid about making mistakes. Okay? It's boring if you don't try. Just take a guess. You can see if you're right or wrong. So 6 of you. Okay. Anybody else want to have a guess? All right, let's see what you said, the 6 of you. It's C, very good, to respond, very good, okay? Okay, to respond to a claim, okay. Next, this 2. This means to listen to the details of the claim and listen to what the claimant and the defendant say about their dispute. What is that? Is that A, B, C, D, E, F, G, or H? To listen to the details of the claim and listen to what the claimant and the defendant say about their dispute. This is what the judge or the court does. This is the phrase meaning the court deals with the case. 7, good. Anybody else? Okay. Yes, D. This means you will hear the case, meaning the judge sits there and listens to hear a case. Good. 3. This word or phrase means to pay the court an amount of money for issuing the claim. When you made that civil claim against somebody, you had to file the papers at court and do what? Pay money. So we... Good. 7, all of you. Get good, Katerina. Good, everybody. You pay a fee. Right. Next. This means you can legally take a person's property when that person does not pay money that he or she owes. Now this is something we haven't dealt with. Let's leave number 4. Let's leave number 4. Let's see what's left again. Let's go to the next one. Right. This means officially announce the result of the case. The judge may give the reasons for the decision. So the judge heard the case, now gives reasons for his or her decision. This would be what? Pretty easy, really. You can guess what it is, I think. Good. F, to give a judgment. Now, in English, we have things called collocations. It's an English teacher's word. It means 2 or more words that are used together so frequently that they have a meaning of their own, independent of the individual words in the phrase. In the law, in the legal English, they're quite often made up of a verb with a noun. So we hear a case, for example, as you've heard, we give judgment. So what we do is we hand down, to hand down a judgment. That means to announce your decision, to hand down. The judge handed down his decision. Yeah? Okay. Now, so to officially announce the result of the case is to give a judgment. Now, let's go on to number 6, which means to send the claim to the defendant's address and make sure that he or she receives it. We have a special phrase for this, very formal phrase. To send the claim to the defendant's address and to check that the defendant received it. We call the papers in the case that we're going to serve the process, because they're involved in a legal procedure. It's the process. And we're going to send this claim, these papers. Good. And they will be, the defendant will be served upon them. It can be served by in America, a process server. Okay. Right. Now, 7. To decide that this person has won the case, what is that? Yes, E, to find in favor. Now, to find, well, we know what find means in ordinary English. You lose something and then you find it. But in legal English, to find means to decide. The court made a finding, means the court made a decision. The judge found in favor of the defendant, means the judge decided. So to find in the law means to decide. That's different from its ordinary conversational meaning. Right, now then, 8, to officially state what someone has to do and how and when he or she must do it. To officially state, the judge says it, okay? The court says it. And they make it official, they make it official. Okay, they make it official by G. They make it a court order. To make an order, the court orders, there is a court order that you will pay the money, hand back the car. Okay. Now, what we haven't looked at is who helps the court do this? Who helps the court keep order, and who helps the court issue summonses or serve summonses or take property if the people fail to comply with the court order, to give back the car, to pay the money? The person who does all these sort of things has the power, they're authorized by the court, to legally take a person's property when that person doesn't pay money that the court says they should under a court order. This person is called what? It's the last answer that we haven't used so far. It's H, the bailiff. The bailiff. This is an old Norman French word. When the Normans arrived in England 1,000 years ago, they conquered the country and they divided it up amongst about 192 families. Each of the families had an area which they were responsible for. They had to answer to the king. These areas were called bailwicks. Bailwick, very old Norman French word. And to help them keep order in their bailwick, they used soldiers. And so the soldiers were bailiffs. The lord, because it was all men, in charge of the area, in charge of a large area, was given a piece of land called a shire. As you know, we have counties now: Worcestershire, Warwickshire, Leicestershire. Yeah. The person in charge of that shire, that area of land, that area of the country, was known as the reeve, the shire reeve. And of course, over hundreds of years, that became shortened to shire reeve. Shire reeve, sheriff, the sheriff, the shire reeve of Nottingham, the sheriff of Nottingham, and his opponent, Robin Hood. Okay, right, so you can see a lot of this language dates back to the Normans. And even beyond that, to the period immediately after the Romans left Britain, 1600 years ago. We have pleadings, petitions, prayers to the court. This is the language of the priests. Because after the Romans left, the only people who knew how to read and write on the island of Britannia were the priests, which is why they made the priests the lawyers. So some of our language goes back 1500 years to the language that priests used, because all they used was Latin. All right, that was a fairly simple little lesson today. Now, this book, let me show you here. Right, this book has 2 levels for each lesson. This was the foundation level, the easiest level. If we move on about 15 pages, we'll go, however, to the higher level. Our next lesson will look at the same topics, but we will look at the language of the higher level: drafting contracts, honoring contracts, breaching contracts, infringing contracts. Yeah. All right. Any questions? Anything we looked at this evening? It was all very simple, I think, but I'm glad it's important you understand these words, especially if you're going to apply for jobs. You must know what it is you're going to talk about. Any questions on anything, anybody?
No, thank you. I have questions, and thank you for this lesson. This vocabulary very important for each lawyers. Thank you.
All right. Now, don't you worry about that. I've recorded everything. I'm going to send you the recording plus some home tasks. I'm going to send you this book as well, as I mentioned last week. And I'm going to send you some exercises from this book for you to complete as your home tasks. At the back of the book are the answers to all the home tasks. So do the home tasks first before you look at the answers. Let me just see what I put here. You're very welcome, Katerina. Thank you very much. Thank you very much, Juliana. Thank you, Anna. Well, thank you, everyone. I'm in Albania. Now, I arrived yesterday. I'll be here for some time. Hopefully be able to go back to Kiev.
Are we having our next lesson on Tuesday?
Yeah, Tuesday of next week. Yeah, same time.
Perfect.
Yeah.
Perfect. Mhm.
All right. Thank you, everyone. Thanks for
Thank
seeing
you.
me.
Okay.
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 Have a
Take
good
care.
time in Albania. Bye-bye.
Thank
Thanks
you
very
very
much.
much. Bye-bye.
Okay.
Bye-bye.
Bye. Bye.
Bye. See you.
Bye, bye.
Bye.
Thank you.
Bye. Bye.
Thank you very much.
Thank you. Bye.
Thank you. Bye-bye.
Bye. Bye.
Oh.
Bye. All right. Stop sharing. Good. Close this on.